Derek Chauvin, day 10 today. The judge had some pretty significant rulings that came out of court early this morning. We're talking about Judge Cahill, and we now have 13 out of the 14 jurors who have been seated. So let's take a look at the board and see what the parties are looking like here today. No new faces that I saw in court as of today. I am going to go back through, though, and probably going to have somebody here at the office help me sort of look through and identify all of the different prosecutors who were on the board, because we heard from the judge yesterday that something like 10 to 12 different prosecuting attorneys are now involved. I've seen several motions for pro hoc vice, which means they're bringing in attorneys who are not licensed in this state to come in and practice law. And so I think this is going to fill up pretty dramatically with some other prosecutors. And somebody told me that one of these guys was actually the attorney general, and then prosecutor Matthew Frank is just the assistant attorney general. So we're going to update a lot of this, but you will notice over here in the jury panel that we are now almost full. This is representative of the different demographics that I have identified this far. And today we added juror number 13, who is a white woman. We've got one person left. Of course, there's no jury selection happening tomorrow, so they'll be back on Monday to dive back in and finish out the panel. And so we're going to go through some of this this morning's early motions, because they're pretty important. I think they might actually have a significant impact on how this trial goes. I know that they will. So let's take a look here. This comes again from the Star Tribune. It says that Chauvin's attorney, Eric Nelson, motioned on Monday. We're going to start off with some of the less meaty comments from court that require some heavy lifting. This is the easy stuff. Today we're talking about, the first thing we're talking about is the motion to continue and the motion for a change of venue. So let's frame this out just a little bit. If you recall, earlier on, I think last week, it was last week, maybe the week, whatever, there was a $27 million settlement that the Minneapolis City Council, or Minneapolis City Council awarded to George Floyd's family that happened right in the middle of jury selection. And Eric Nelson said, hey, this is biased. This shows that the government itself is prejudiced against our client. And so what we need to do is ask for a continuance. We need to push this thing out another 6 months or 9 months so that anybody who's been sort of in close proximity to this case has time to forget about it, so that it can sort of dissipate from their minds. There'll be another thing that pops up and they can let the volume go down a little bit, let some of the tensions dissipate. And so that's one. We want a continuance. We want to just bump it out. So the judge ruled on that. The other thing that the judge ruled on was whether or not a change of venue was appropriate. So rather than having the trial in this city, can they just pick it up and move it to a different part in Minnesota so that it is less prejudicial? Remember that they're right in the middle of the city where this entire incident happened. And of course, the tensions are going to be high there. It's going to be on the cover of every newspaper, on every radio station. You're going to see every restaurant or even just shop that you go into that has a television is probably going to be covering the trial. And so, these people who are on the jury panel or who are even working on the trial, they are in sort of the midst of a turmoil in their city. And so the next thing that Eric Nelson wanted to do was say, well, we're going to take it out of the city. Let's just remove it here and take it someplace else where there's less prejudice. And so the judge was ruling on those today. We're going to start with those. Those are easy things to kind of get through. Chauvin's attorney, Eric Nelson, motioned on Monday to postpone the trial and move it to an unspecified county because he felt the settlement had unfairly tainted the local jury pool. Surprise development occurred a week into Chauvin's trial, right in the middle of jury selection. Nelson raised the issue again yesterday, after city officials held a news conference that morning and explained the timing of the settlement's announcement. The briefing was part of a regular weekly media availability the city began holding before the trial began. And this is what the prosecutors said. They said, hey, this had nothing to do. They weren't coming out and giving a statement specific to this trial. They just do this regularly. And because this is in the news, they had to address those questions. Now, Eric Nelson, the defense attorney, said, well, that's still inappropriate, right? They're commenting on a trial. It's pending. It's the city being prejudicial by coming out and sort of endorsing their settlement, but justifying what they did to support why they did it. And he's saying that that is prejudicial and inappropriate. He says here, his quote, "I would note that the city of Minneapolis indicated that the timing was of the essence, yet the agreement had not been finalized and will not be finalized for a month," he told Judge Cahill. "It raises the question of whether the announcement was necessary, regardless of the timing. I just wanted to make the court aware this is an ongoing public discussion that the mayor and the city are engaging in." So they announced it, but the agreement was not finalized. So why didn't they just announce it after it had been finalized? Is it because that they had the intention of interfering with what was happening here? I don't know. That's what Eric Nelson had to say. So he was using that as justification to move the trial into a different city, a different county, or to ask for a continuance. Here is Judge Cahill, who is issuing his ruling on it, denying both.
Now, as to the motions for continuance and for change of venue, the purpose of a change of venue is to ensure that the defendant has a fair trial by an impartial jury. The same is true as the basis for the defense's latest motion to continue, with the hope that as time passes, people forget some of the pretrial publicity. Unfortunately, I think the pretrial publicity in this case will continue no matter how long we continue it. Perhaps some of it may, with time, be forgotten by people. And as far as change of venue, I do not think that that would give the defendant any kind of a fair trial beyond what we are doing here today. I don't think there's any place in the state of Minnesota that has not been subjected to extreme amounts of publicity on this case. Change of venue is an option in the rule when there is extensive pretrial publicity that is prejudicial, and there was prejudicial pretrial publicity, including the latest actions by the city of Minneapolis in settling the case. I'm not questioning whether they could or should settle the case at this time, but the bottom line is when it's reported by the press, it can affect the jury, it can prejudice or taint our jury pool. I'll be very honest, when that was first brought up by the defense, I thought they were overstating. I thought this really won't have an effect. People know it's a different case, different situation. I was a little shocked when we called back all the 9 jurors who had been seated, and 2 said it did move them off of being fair and impartial. We had all accepted them as fair and impartial jurors. 2 of them basically said that they could not be fair and impartial any longer. I was surprised that it had such an effect.
All right. And I was not surprised. I'm not sure that anybody else who's maybe not a judge was surprised. He said, he goes on to, if you continue watching, he goes on and he says, well, that just may be just judicial bias. You know, I'm a judge. I know that you can separate these things. This is relevant. This is not relevant. To a layperson, they may seem both relevant, like we need to talk about them both. But because he's got a skill set here that he's used to sort of dividing information and segregating it from itself, that wasn't a big deal to him. But other people, as we saw, 2 of the jurors said, no, I mean, I could have been fair and impartial. I already made that avowal to the court, but now after I heard that there was a $27 million settlement, I can't do that anymore. And I think many people who are non-lawyers and even lawyers like myself were going, yeah, this was catastrophically bad. Feels like intentional interference by the city council. The judge thought maybe it wasn't that big of a deal. Turns out it was. And so he's making a note of that. Now, if you watch the full clip, he goes on for quite some time to go through and explain exactly how many jurors they questioned, how many they struck, how many peremptory strikes both sides still have, and basically the extent that the court has gone through in order to get the jurors on the panel that they have. And so I think this was the right move for him, right? I think that it was necessary to continue the trial. They've already got 13 jurors picked. At the time that he was making this statement, it was only 12, but that's still almost there. 12 of 14 is pretty close. And so there, the train is still mostly on the track. And I sort of agree with him. Even if you think that that this is an unfair venue, are you going to move it anywhere else where it's going to be more fair at this point in time? Not really sure that you could or not. Not sure what the ultimate impact of that would be. Whether it would change anything materially or not. And so I think, this judge is being consistent. If he's anything, he's consistent. He's a lot of things, but he's very, very consistent. He's been saying that, no continuances. We're moving this thing down the road, and he's sticking to that. And so, good for him. This thing is staying on the tracks. Opening arguments are going to start on the 29th, and hopefully they finish jury selection starting on Monday. So it's going to be staying in this city. It's not going anywhere. It's happening as scheduled. That's Judge Cahill. All right, so that's kind of the easy lifting. Now we're going to get into this really, really messy ball of yarn. And the judge notes this as well. And so I only took a couple clips here because I could have spent probably 5 hours talking about this one motion, and we're just not going to do that here. If you want to watch the full clip, please go ahead and go do that. But the judge really goes on and he talks about 10 minutes, and he's sort of separating this issue about this 2019 case. And let's frame this out just one more time. So in 2019, George Floyd was arrested on May 5th, I think it was, for something very similar to what we saw in the May 25th or 26th case in 2020. Very similar set of circumstances. And the judge is going to go through and sort of compare and contrast the two. And what the defense wants to do naturally, and this is standard stuff, Now, typically, these roles are sort of reversed. Typically, the prosecution is prosecuting a defendant who is charged with a crime, and they want to get that defendant's crimes into court so that they can show that this person's a bad person. They're acting in conformity with their prior cases. So if they stole the candy bar 3 times in the past, we can kind of presume that they stole the candy bar this time also, just because they did it so much in the past. So that's typically what prosecutors want to do, and they're trying... They tend to try to get that stuff into court, and the defense typically tries to get that stuff out of court. Here, the hats are reversed a little bit. So the defense now, since George Floyd is the quote victim, the alleged victim, the decedent here, they want to bring his priors in, and the prosecution wants to keep it out. And so they're sort of, the hats are on differently this time around. But it's a very important issue, and you can see why the defense might want to get evidence of a prior in, because their defendant is the officer who was investigating George Floyd, or was at least involved in the incident. And so the theory here is that the defense wants to get this into court because it's going to be very, very persuasive in their case, very compelling information, because the facts of the 2019 case very similarly mirror the facts of the 2020 case, in particular as it relates to what the judge is calling concealment of drugs by ingestion. So in 2019, a lot of evidence that when the police came up and approached George Floyd in his vehicle, he consumed a bunch of drugs. There's evidence of that. We're going to hear what the judge has to say about it. Then in 2020, something very similar happened, and we're going to hear more evidence about it. In fact, this next clip that we're going to play is pretty damning evidence, in my opinion. And so we're going to hear what the judge has to say, but understand what we're doing here and understand why this is so messy is we've talked about what evidence can come in and what evidence cannot come in. And the sort of the balancing test that we are always talking about in law as it relates to these issues is whether the material is more probative than it is prejudicial. So it's a scale. If it's more probative than it is prejudicial, we'll let it in. If it's more prejudicial than it is probative, we're not going to let it in. If it's going to confuse the jury, if it's going to inflame their emotions, if it's going to just sort of mislead them in any way, if they're going to be focused on the bad information and not what the information is intending to prove, then all of that information cannot come into court. And for good reason, because we don't want to confuse the jury. We want them to be ruling on this case here and now, what happened in this particular incident, forget the other stuff. If it's relevant, if it's probative, if it goes to the underlying issue in this case, we'll let it in, as long as it doesn't overly prejudice the jury, confuse them, inflame their emotions, and what have you. And so the judge right now is dealing with what I think is a very important fact in this case for a defendant, that maybe George Floyd did have a proclivity or a modus operandi where anytime that he was approached by law enforcement, he would just consume whatever drugs were on his person or chew them up and spit them out or make them unsort of identifiable using his body to just dissipate the drugs. And so if that was something that did happen, and that it did, apparently, according to the judge and according to the evidence that we're going to hear, that is, in my opinion, relevant to how he acted in this case. But it's also highly prejudicial, clearly, because you do not want the jury to come into court and say, oh, he did that in 2019. Well, we can just presume he did that in 2020. That's not fair at all, because you can't presume that. You got to prove it that happened in this case in order, or the defense has to at least raise reasonable doubt in this case as to whether or not the drugs were the cause of death and not what they're calling, positional asphyxiation, whether it was Derek Chauvin's knee on his neck or the drugs that ultimately resulted in George Floyd dying, as we saw on the side of the road. And so does the 2019 case, if it comes in, the judge is going to be very clear. Only bits and pieces of that can come in that go to the primary issue here, which was the cause of death. And more specific than the cause of death, what was the mechanism of death? What was it that killed George Floyd? Does the 2019 case in and of itself prove any of that? Not really. But because of his prior heart condition, because of some of the same indicators here of last-minute drug ingestion or last-minute concealment, if that did happen in this new case, or even if it happened in the 2019 case and it caused heart problems or hypertension or any of the atherosclerosis or any of the other issues or ailments that he was suffering, it might be able to be probative as to the medical ramifications of the 2019 case. And so you can see here, we're just sort of unpacking the layers of this onion. It can get very messy. The main takeaway here is that the judge is going to let some information in and some other information has to be precluded. And he sort of split it right down the middle, as many people were predicting. And the question here is, how is this going to play out in court? So the judge is just fleshing out some general rules about this 2019 stuff. This, in my opinion, is pretty not a good decision for the prosecution. The jury is going to hear some of this evidence, and I think it's pretty compelling. We're going to see how this ultimately fleshes out in court. But the judge is just laying some framework right now. He's laying some ground rules. And as the judge is going through this, if you watch the whole thing, he goes on for about 10, 15 minutes on this topic. But he's also sort of working through it. I think he's got it all written out, but he acknowledges that they're going to issue a formal memorandum on this stuff. They're going to write this down. They're going to document it. He's giving his oral ruling, but this is complicated. He's going to flesh out, I mean, literally, what portions of the body camera can come in from this second to this second, what statements can come in, what lines of questioning, what words that were exchanged back and forth from all of that incident. And even beyond that, what can psychiatrists and psychologists come in court and testify about? Because the main question is, does it go, when we're talking about whether evidence can come into court, we have to ask ourselves, what is the purpose of that evidence? Why are we bringing it in here? If we're just bringing it in here to make George Floyd look like a drug addict who gets arrested by the police, that's not a good reason. That's not probative of anything. That might be your opinion, but that doesn't answer the question about the mechanism of the cause of death in the 2020 case. And so only information that can help us answer that question, what was the mechanism, what was the cause of death, can come in. And the judge, as you can understand this, arrests and body camera interactions, any interactions with law enforcement are full of conversation. They're full of words back and forth. There's a lot of stuff that's happening. And the judge is trying to sort of strip the meat sauce from the spaghetti. I mean, it's all just interwoven in there. They're trying to rip the sauce out, kind of strain it out, and separate the probative stuff from the prejudicial stuff. And it is a complicated thing. So, we're going to get into this. This is high level stuff, but it is important because some of this evidence is going to be heard in front of the jury. This again comes from the Star Tribune. Says, on other motions on Friday, Cahill ruled only portions of events surrounding Floyd's drug arrest in Minneapolis in May 2019 are admissible in this trial, namely any evidence or testimony that directly relates to his medical condition after having a police officer point a gun at him and take him into custody. And so we're going to see this distinction between medical condition, so information that goes to, what are we talking about? The mechanism, the cause of death. So the medical condition information is relevant to that because this was a prior situation where he ingested a significant amount of drugs that caused him to be hospitalized. So that impacted how he can function as a human being. That's medical information that might be relevant in the 2020 case. But other information cannot be admitted. Not to be admitted, the judge said, is anything about his emotional behavior, such as calling out for his mother, something he did in both encounters with the police. He also blocked Floyd being something. So they didn't finish their article there. The judge said he will allow the trial the admission of a portion of the body camera from the 2019 arresting officer. Floyd's blood pressure results at the scene, again, because that is medical information. The body camera from the arresting officer will show the potential ingestion of the drugs. And they're also going to look at a suspected illicit drug pill in his car and his statement to the paramedic for the purpose of her diagnosis. And so this is a very interesting sort of exception to the rule. Typically, statements that are made out of court are considered hearsay. You want stuff to be said in court. That's where you can cross-examine it. And by cross-examining statements, that's how you can vet their reliability, their trustworthiness, because you get to cross-examine them. If somebody is making something up and there's nobody to ask them questions about it, well, they can make up whatever they want without any fear of repercussion. But in court, when you get the opposing side who gets to come out here and say, that you said you were there, but I got this that says you were here. How about that? And then that's how you sort of root out the untruths that can sometimes slip out of people. And so it's very important that we're able to sort of have that dialogue that takes place in court. What the judge is saying here is that this evidence that George Floyd was having a conversation with a medical person was outside of court, so that evidence typically doesn't come in because it's not reliable. We can't cross-examine that. We can't bring it into court and vet it, kind of put it through the grinder of truth. But here, because George Floyd was having a conversation with a medical person, there are exception rules under the hearsay rules that say that that testimony, that evidence, that statement, even though it was made out of court, is more reliable just for the fact that it was a conversation with a medical person. People typically don't lie to medical people because why would you do that? You need help from them. That's why you're in that conversation. You need them to save your life. You need them to perform whatever necessities are necessary to make you well, make you better. And so we kind of lean on that evidence as being more reliable. And so we'll let conversations between people and medical providers, as long as they're within the context of a medical conversation for the purposes of providing those services, we deem that to be reliable, and some of that can come into court. And the judge is going to allow that here as well. He said, cause of death is clearly an issue here, noting that the defense and prosecution are at odds in this area. And that's exactly right. What caused the death? And this is why when we did our original defending Derek Chauvin, we spent a lot of time on causation. Was it the drugs? Was it the positional asphyxiation? They're going to duke that out in court with a battle of the experts. So I want to show you this next clip from Judge Cahill. What he does is he goes through, he compares 2019 to 2018. He goes on for several minutes sort of comparing and contrasting the two. And he's going to give us some indication about what comes into court and what does not come into court. But this next clip is where he's detailing some of the similarities as it relates to the drugs and the concealment of the drugs by ingestion, which I think is just such a, I didn't know about this until we started to hear this evidence in court. There were a lot of rumors about this, saw a lot of information that there was, a picture of George Floyd with something in his tongue, whether that was gum or saliva or a fentanyl pill. Nobody knew. But now we have the judge who's got some evidence that has been submitted in front of him, who's saying, yeah, looks like this is going to come out in court. Looks like both sides get prepared for it, which is kind of a game changer in many ways. If you're on the jury and you're able to hear these things, it's going to be compelling. Here is Judge Cahill, who is telling us a little bit more about the 2019-2020 case as it relates to the drugs.
As to cause of death. On May 25th, 2020, the date of Mr. Floyd's death, there is a very similar starting situation as on May 6th, 2019. That is, an officer approaches him while he's seated in a car. He is at gunpoint. The police have a gun pointed at him. And the May 25th, 2020, was Officer Lane. They both holster their guns at some point, but there is a shocking interaction between the police and Mr. Floyd. Shocking to Mr. Floyd. That is fairly clear. There is also evidence of drug concealment upon being stopped by the police. Basically concealment by ingestion. In other words, that he was eating and otherwise hiding drugs. On the May 25th, there is evidence of that from a white object of some sort being seen in a photograph from a video grab. There is a pill in the backseat of the squad that he was ultimately taken to and through, which has Mr. Floyd's DNA and saliva, both, in the back of Squad 320. Toxicology results showing fentanyl, which is, as we all know, a powerful opiate, and methamphetamine.
A pill right in the back of the car, George Floyd's saliva, George Floyd's DNA, and then he died. Toxicology reports already talked about that. Fentanyl at 11 nanograms per milliliter, a lot. And some of that evidence is coming in. I'm going to show you this next clip where the judge details that some of that is coming in. But let me just give you a little bit of background here. Well, let's go to the next clip first, and then we'll flesh the rest of it out. Here he is explaining. This is Judge Cahill talking about what can come into court.
So what we have here, what I'm going to allow, is a portion of the videotape of the one officer from the time he approaches the car until Mr. Floyd is out of the car and handcuffed. And I apologize, I don't have a timestamp, but it's very clear that there's a shot of the back of his shirt. He's wearing a black shirt. At that point, he's been handcuffed. That's all that would be admissible. The pills that are in the crack of the seat would also, there's a photograph of that would be admissible also as part of that scenario. And then the blood pressure and Mr. Floyd's statements regarding that were made for purpose of that medical diagnosis. The whole point here is we have medical evidence on what happens when Mr. Floyd is faced with virtually the same situation. Confrontation by police at gunpoint, followed by a rapid ingestion of some drugs. We don't know exactly how many, but there was an admission that he had done it at the time of the stop. That is medical evidence. So we don't have the benefit of on-the-scene medical vital signs on May 25th. So the May 6th, 2019 case is relevant only to that extent. Mr. Floyd's emotional behavior, calling out for his mother, all that is not admissible because the emotional behavior in a state of mind is not relevant. The May 6, 2019 evidence is only admissible for the limited purpose of showing what Mr. Floyd's, as an example of Mr. Floyd's bodily reaction, his physical symptoms upon being confronted in almost the exact same situation.
Yeah, so this evidence can only come into court for medical purposes. None of the other stuff is probative, whether he was calling out for his mother, whether the judge goes on, he says that there was a situation in 2019 when he was taken back into the hospital. The medical doctor said something like, well, you might have a heart attack. Even the judge said, no, that can't come in because it's hearsay. She can't be cross-examined about it then, but if she did come into court and testify about it, then that would be permissible because, again, she can be cross-examined. So, we're going to have people from the 2019 case, it looks like, who are going to come into court and testify about that for a couple different things. Number one, what did that do to George Floyd's body? If he ingested a bunch of drugs, he was hospitalized, his blood pressure was through the roof. The judge talked about that. Some of that medical information can come into court, but the other stuff cannot. Anything about him getting violent in the hospital, all of that stuff is just too prejudicial, and it doesn't answer the question, what was the mechanism or the cause of the death? What was it that failed in his body? Was it his trachea because he couldn't breathe because of the positional asphyxiation, or was it his body gave out because he had a heart attack from an overdose of drugs? And what information from 2019 will help us answer that question? So the judge is really going to, decipher this. As I mentioned, he does go on and he says, we're going to delineate all of this out in a memorandum that both sides are going to have. And so when we get that, we'll be able to take a look at it. But again, this is sort of predetermining the rules. This is like before you step onto the football field, you sort of flesh out the rules, but you don't know how the plays are going to go. You don't know what's going to happen when you step up to the line. You know what your offense is running, but you don't know what the defense is running and whether that's going to cause a problem or whether somebody's going to try to do something that violates the rules. That's why you get a penalty flag. The referee says, nope, not allowed to do that. So that is very likely to happen in this case. We're going to hear a lot of objections. We're going to hear a lot of correcting the records, because this is a little bit of a minefield. It's like kind of navigating through a maze a little bit. The judge is going to be watching both sides, and the attorneys know what to do. They know what the rules are. They know what they can get into and what they cannot get into. But what about the other witnesses? What about the expert witnesses? What about the people who come into court? The attorneys are going to have to prep them and make sure that somebody doesn't blurt out something that the judge said could not come into court. If they do, that's a big problem. The judge is going to have to correct some of that record. And so while it may be easy for attorneys to sort of, and it's not easy, by the way, for attorneys to sort of play by those rules because there are so many of them in a case like this that has so many different issues, you might just forget about one, or you might think that you heard a rule one way, or the judge, a new issue pops up that the judge didn't like. And so it can be very, very tricky. And those are for lawyers, not even for lay witnesses or for expert witnesses even who don't have a lot of experience testifying. So the judge is kind of splitting this down the middle. I think that ultimately this is a big win for the defense. I think that the fact that they can talk about anything from 2019 is a win for them. I think the prosecution today is not going to be happy about this ruling. We'll see if they do anything about it on Monday, renew any motions, or try to offer anything else and get the court to reconsider some of this stuff. So it's warming up. The temperature is warming up here, and we haven't even started opening arguments yet. So let's take a look at the jury. We're going to transition. Number 13 made it to the panel. This is Who She Is. With those motions settled, it was back to jury selection Friday morning. A 13th juror was chosen. A woman who has worked in customer service said she is an animal lover, especially dogs. Attorneys on both sides questioned her about volunteering on behalf of the homeless and a concern for affordable housing. She said she saw the off-mentioned bystander video of Floyd's arrest and wrote in her juror questionnaire months ago, quote, "This restraint was ultimately responsible for Mr. Floyd's demise." Then, that said, she pledged under defense scrutiny on Friday that she could presume Chauvin innocent, as the law requires her to do. The prosecution saw the woman as having a fairly favorable view of the police after she said that if a suspect is, quote, not listening to what the officer's commands are, obviously something needs to happen. So we've got something here indicating that potentially Chauvin's hold on him caused his death, but maybe that some of that hold was justified because he wasn't listening to the officer's commands. Says here, she was more critical of the criminal justice system once cases move into the courtroom, saying, you have a better chance of proving your case if you have a private lawyer than if you have a public defender. Oh, she's being mean to the PDs. And there are instances when innocent people are convicted. I agree with that. So, kind of an even-handed juror. Somebody on both sides. A white woman we know, suspected to be in her 40s, I believe. And so we're still sort of piecing some of this together. Here's what the panel looks like. You're going to notice now that the panel got a little bit whiter today. We've got 1, 2, 3, 4, 5, 6 people of color, which means we've got 7 white individuals who are on the panel. And we talked yesterday about the demographics over in Minneapolis, and we're going to see whether number 14 makes it an even split or whether this jury panel is, we're going to leave it at that. How about that? All right, so here are the demographics. This is what it looks like on the high level. Still missing number 14, of course. We don't know what number 12 does. 50, she is in her 50s. She's said Floyd not completely innocent, but excessive force is also bad. Customer service, dog lover, individuals in her 40s, female, and white. So this is the demographic snapshot. Let me move myself out of the way there. We got one left to go. We'll see how that works out. So let's take some questions over from our Locals platform, watchingthewatchers.locals.com if you want to ask a question. We got Woodworking Medic in the house. Says, Robert, how is it fair that the prosecution has 1,000 attorneys and Chauvin has Mr. Nelson? To me, the jury will look at that and say maybe no one wants to help Chauvin because he's guilty. That on top of the $27 million settlement seems like the final nails in the coffin. Well, Woodworking Medic, I think that this is just standard operating procedure for defense attorneys. We're kind of used to being a David versus Goliath situation. It's typically solo lawyers or small law firms. We're a small law firm compared to some of the big law firms that have thousands of lawyers in there. We're very small compared to them. And so, we just have the resources that we're able to muster up. We go against the big government that has billion-dollar budgets and hundreds of prosecuting attorneys, not to mention thousands of other support staff, all of the different law enforcement individuals, not private investigators, government investigators, detectives, and just, layers on layers of bureaucratic support that defense lawyers don't have. So I think Eric Nelson's cut for the job. I think he understands how this works. He knows what he's doing, and he seems to be very competent to me. So from a capability perspective, the way that this works is apparently the police union has hired Mr. Nelson, and so they're going to be supporting and funding the defense. And I don't know how that works. I don't know what the intricacies of that are. I don't know whether Mr. Nelson does not want any help or whether he is asking for help and he's being denied it, or whether he thinks, I can handle this. It's a kind of simple causation case. And I looked at his bio, and he's done a lot of DUI work, and so he's probably very familiar with toxicology and how to use expert witnesses. And so, I kind of like the David versus Goliath situation. And to me, it kind of makes me feel like the government maybe doesn't think that they have a good case here, because they really are sinking a lot of resources into it, knowing that every little minor detail is necessary in order for them to win. That's just speculation. I don't know. Here is Pinky number 2, says, Rob, what's the chance the city wants the case moved? What's up, Pinky? I think that the chance is 0. I don't really think that they want it moved at all. I think it happened there. They want the resolution there. They've already got the court set up. They already have all of the security apparatus installed. They've got barbed wire and chain link fencing and concrete barriers. And so they're basically set up to keep this thing moving forward. And it sounds like they are. Judge said no to a continuance. News Now Wyoming says, I found it interesting that the second juror today said after they heard about the settlement agreement, it cemented their opinion that Chauvin is not guilty. I found this interesting because it is opposite of what we have heard the reaction so far. Any thoughts? Yeah, so I think the prosecutor was touching on this. He was saying that he wasn't sure which way that it cuts. And I think this juror sort of is supporting that perspective. If you are somebody who says, well, let's say you're very cynical of government, or let's say that you think this whole thing was, I'm not saying this, but let's say that they thought that this whole thing was blown out of proportion. It's sort of this woke movement where everybody's claiming racism, but it wasn't really racism. Let's say that if you think that the city council is full of a bunch of, idiots out there, whatever, that maybe they would pay this off to make this go away, sort of as overcompensation for something that wasn't in fact a crime, right? They're overcompensating for something. And I think that's where the prosecutor was going with that line of reasoning, saying, well, if people think that the family got paid off, they're made whole, then maybe they can not find him guilty for the criminal charges because the family has already been made whole. So it's sort of conflating the two cases. One's civil, one's criminal, but if they've been rectified civilly, then some people wrongly might just presume that means that the criminal case is no longer relevant. It's moot, in other words, because the family has already been settled with. Now, I don't think that is the majority. I think that most people would see them in parallel, not working against each other. And I think we saw that from the two jurors who were excused. But I think that was the prosecutor's argument, is that if people think that it was paid off, that they were paid off, maybe they're going to use that as justification to come down on the criminal conviction. We have another one from J-Bone, says, any thoughts on potential jurors doxing themselves and not being dismissed for cause? Well, I'm pretty sure that the judge gave them some pretty strict guidelines on that. Now, the judge did say, I didn't see this yesterday, but apparently yesterday he said he was going to release more information about them. And we were having a conversation about this on Clubhouse yesterday about whether the judge was talking about giving the press and the media more information about the jurors, maybe ages, demographics, or some other information from their jury questionnaires, or whether he was specifically going to be releasing their names. And I just can't imagine that he's going to be releasing their names in the middle of the trial. That seems totally off the wall to me. I don't know why he would do that, because the pressure of society would come to bear on them. And so that didn't make much sense to me. But if the jurors, outed themselves, then I think the judge might, that would be a catastrophic problem. That might, warrant a mistrial or something like that. I don't think that that's going to happen. I think that they're going to get a very stern talking to. They're going to take an oath. They've already been, sworn in during their initial questioning. And so hopefully that doesn't happen, because that could be a whole different can of worms. All right. And then the last question before the next segment said, Rob, if you were on the judges panel for the final round of Miss Nevada, could you vote for a black transgender contestant? Is that prejudice for black or transgender people? I'm not going to answer that question. All right. I'm not going to be it's not going to be a thing. Right. And all that's going to do is just anger probably everybody. And even the fact that I'm not going to answer that question is probably going to anger a large part of people. So we're just going to leave that one alone. Thank you, though, for trying to needle me with that. That's a fun one. So a black transgender contestant for the final round of Miss Nevada? Want to know? Too bad. We're not answering that. All right. So next question